Good morning, ladies and gentlemen. Today I am standing before you to talk about the Companies Act. The first important thing is we have to understand the meaning and definition of company. Now, when we talk about the meaning of company, I want to tell you that company is basically a group of people with a common objectives. And we understand that with the growing needs in commercial transactions, formation of companies has become mandatory, because for the simple reason that the company enables you to do your business in a much better manner with a limited liability, which is the biggest advantage so far as the company is concerned. And to regulate the companies in our country, we have a company law which is basically established to govern the acts of the companies. So the next important point, which of course is very essential to be driven into your minds, is what are the basic features of a company. Now, a company is, in legal terms, we say an incorporated entity. Now, what do you mean by an incorporated entity is that a company comes into existence only through registration, unlike a partnership. Now, the very important difference between partnership and company is that in a partnership firm, when you do a business through a partnership firm, the members who are the partners, their liability is unlimited, meaning thereby the creditors who have given loans to the partnership firm, they can file a case against the partners individually, and thereby the partners' liability is unlimited. But so far as the company is concerned, the company is a better way of doing commercial transactions for the simple reason that the company, its liability is limited. Now, the second important point is that a company is an artificial person. It is not a natural person like you and me. We are human beings, of course we are natural persons, but the company is given a legal personality by the law, that is the Companies Act. Now, so far as the company is concerned, when we say it is an artificial person, because it is not a natural person, the company doesn't have any independent mind. It cannot act on its own. So the powers of the company are executed by its board of directors, who are the agents of the company. So these agents, who are the directors of the company, they execute the powers of the company, and they are the natural persons, and the company is an artificial person, and that is how the company acts, through the board of directors who form the heart of the company. And the third important point, which of course is very fundamental, is that the company has got a separate legal entity. What does it mean? For example, you form a company, you are the members of the company, but when you form the company, you bring the company into existence, but once the company is formed, the company acquires a separate legal personality. It is different from the members. You constituted the company, but your company and you are not the same. You are the members, and the company has got its own independent legal existence. And once it becomes a legal entity, of course it is different from the shareholders who earlier were responsible for the formation of the company. So these three important points: it is an incorporated entity, it is an artificial person, it is a separate legal entity. These points are very important. Now, the next important point is, what are the various kinds of companies? Now, the kinds of companies, we say that based on the formation of the companies, we have two categories of companies. One is the statutory companies, the other one is the registered companies. And the second classification is based on the number of members. How many members are you? And depending on the members, the size of the members, the companies are again divided into two categories. One is the private limited company, and the other one is the public limited company, based on the ownership of the company. For example, who has got the control over the ownership of the company, and that's a very vital point. And based on that, the companies are divided into holding company and subsidiary company. And the last and the most important one is based on the liabilities of the members of the company. You remember I told you that a company, so far as the company is concerned, the liability of the members is limited, unlike a partnership firm where the liability of the partners is unlimited. But when we talk about company, the liability is limited. That is the biggest advantage in forming a company. So basing on the liabilities of members of the companies are divided into a company limited by shares, a company limited by guarantee, and of course an unlimited company whereby the liability is unlimited. And now we come to a very important slide, That is, we talk about what is the nature of the company. See, companies definitely are established with a view to do commerce and trade. But there are some companies which are not formed to do any particular business, or they are not formed to do any particular trade. They are non-profit companies, and company law enables you to register even non-profit companies under the Companies Act. And these companies are formed not to derive profits out of its operations, meaning thereby, my dear, it's a very important point that these companies are basically established to do certain welfare activities for the people in the society. And these companies are non-profit companies. Whatever profit is generated, that profit is used for the promotion of the basic objectives of the company, which are charitable in their very approach. And now the next important company is government company. Now what is the government company? See, in India, the government can also form companies. Government also enters into the company way of doing business, and the government invests its money, and government also becomes a shareholder. That's a very important thing. Now, when the government becomes the shareholder, we say the government is the shareholder. But because the government is the shareholder, the government is investing its money. Like we invest our money in commerce and trade, the government is also doing business through the medium of a company. And the company, of course, is the best method for the government also to do its business or trade. So when the government invests its money, and in 51% of the paid up share capital in that particular company is owned by the government, meaning thereby the state government or the central government, or a company which is owned by either the state government or the central government, then it is called as a government company. So what is the government company? The government company is the company in which 51% of the paid up share capital is held by the government, be it the state government or the central government, or a company which is of course held by the state government or a central government, state government or central government. Now we come to what is a foreign company. Now the very name indicates that this is a company which is incorporated outside India. I already told you what is the meaning of the word incorporated. Incorporated means bringing the company legally into existence. Now when you bring a company legally into existence, that is called as incorporation. But this foreign company, it is not incorporated in India. It is incorporated outside India. But a very basic point, the basic point which must be driven into the minds is that the company is of course established outside India, but it should be having a place of business in our country, that is India. And there should be a place of business in our country after the formation of the Companies Act, or if the place of business is in existence before the formation of the Companies Act, it should continue to exist even after the coming into existence of the Companies Act. So a foreign company is basically a company incorporated outside India, but it has got a place of business for its operations in India, then only it can be called as a foreign company. If it is not having a place of business in India, then it cannot be called as a foreign company. Now we come to the most important point. Now, like we human beings, we have a basic structure. For example, we have blood, skeleton, and these are of course the basic things in our body. In the same manner, a company also has got a memorandum. Now the memorandum of the company, it is the basic document of the company which will explain us as to what are the objectives for which the company is formed. Because the company is formed with a particular purpose. The company has got certain objectives, and these objectives are very vital for the very functioning of the company. And these objectives are reduced into a document, which document is basically called as the memorandum of the company. So if you want to know what is the objectives of the company, then you have to consult the memorandum, through which you can understand as to what are the objectives of the company. And now we come to a very important doctrine, which is known as doctrine of ultra vires. Ultra means beyond, virus means powers. Now what we understand is that a company, whatever transactions it enters into, it should be within the powers of the company. It should be within the objectives of the company. A company cannot enter into a commercial transaction which is outside the basic objectives of the company. And if any creditor or any particular financier, he enters into a contract with the company without consulting the basic memorandum of the company, and tomorrow if it is known that the company has no power to execute such a particular commercial transaction, it is outside the memorandum, then the company cannot be made liable because the company doesn't have the power to enter into such a transaction. Then we come to what are the articles of the company. Now the articles of the company are basically the rules and regulations of the company, and they regulate the internal management of the company. And through these articles, the objectives mentioned in the memorandum of the company, they are achieved. And every private limited company must definitely have the articles of association, meaning thereby in its articles the private company regulates the number of members, and most importantly it puts a restriction on the transfer of shares. And a public limited company, of course, it can also have articles of association, or it can have verbatim the articles which are given in the Schedule A of the Companies Act. And after understanding what is the memorandum, what is the articles, now we come to a very important area, that is the capital of the company. The capital of the company, where the members invest their money, and that money is called as the capital. And we have got some kinds of capital. For example, we have got what is known as authorized share capital, subscribed share capital, paid up capital, reserve capital. Authorized share capital is the registered share capital of the company. Subscribed share capital means the capital which has been subscribed by the members of the public. Paid up capital means the amount which is paid up by the members to the extent it is called as the paid up capital. Now reserve capital is something which is reserved. When the company enters into a liquidation process or the winding up process, then the reserve capital is used for the purpose of satisfying the creditors of the company who have given the loans for the purpose of running the company. And now when we come to the kinds of shares, basically we have got two types of shares. One is the equity shares and the other one is the preference shares. Now what are equity shares? Equity shares are shares which carry voting rights. Now because they carry voting rights, these equity shares, now the equity shares are not like the preference shares. They are not given any preference in the payment of the dividends or in the payment of any particular debentures. They are not given any particular preference, equity shares. And now when we talk about the equity shares, what we understand is that they are not for the purpose of being given any preference, unlike the preference shares which are given preference over the equity shares when it comes to the question of winding up of the company or the liquidation of the company. And now we come of course to a very significant area in the Companies Act, that is the corporate governance. Now what is this corporate governance? Why is it so important? Because as I told you earlier, the company is a legal person and it's not a natural person. It requires some human beings who become the mind of the company. And these human beings who become the mind of the company, they are called as the directors. And these directors, they are very integral to the very existence and for the growth of the company, because they direct the management of the affairs of the company, they plan the affairs of the company, and of course the directors must also be concerned with ethics, values and morals, because that is what makes the company a entity which inspires the confidence of the people. And these directors, they perform their duties, they have to perform their duties, obligations and discharge the responsibilities diligently and act in the best interest of the company, that is the shareholders of the company, because they are the custodians of the shareholders of the company. They are the trustees of the shareholders of the company. They have to manage the affairs of the company in such a manner that the company derives profits, but the profits are derived in an ethical manner, and the shareholders and the members of the public, they continue to repose confidence in the faith and the integrity of the directors. Now this corporate governance is mandatory for all listed companies. So finally I would like to conclude by saying that the Companies Act is a very important act for the purpose of doing trade and business, and it is the most convenient method of doing trade and business. And the biggest advantage is the company is an artificial person, it's a legal entity and it's different from its members. So the members are very secure, the company becomes liable, the liability of the members is limited, and that way they find it very convenient to do commerce and trade through the medium of a company, and that way the company becomes the heart of present the world commercial transactions. Gentlemen, that was the lecture with regard to the Companies Act. I hope you have understood the information given, and in case you have any doubts, then you consult our website, which of course more material is given and the material can be consulted, and thereby whatever doubts you have, those doubts can be removed. Thank you.